G&S Transport versus Medina. Medina was hired as a driver of G&S, more popularly known as Avis Rent-A-Car, and employed thereat for 7 years with no derogatory record. However, one night, Medina got engaged in a heated argument with a co-employee. Medina averred that he was on his shift at the time of incident. At around 5 p.m., Medina left the premises of G&S. However, at around 10 p.m. on the same day, Medina returned to G&S to retrieve his personal belongings. At the gate, Medina chanced upon his co-employee, Felix Pogoy, who was staring sharply at him. A heated argument with shoving then ensued. Another employee, Jose Vigayan, broke up the melee and led Medina away from Pogoy. G&S concluded that Medina violated the code of discipline when he fought with a co-employee inside the work premises. Thus, Medina was terminated from employment. Aggrieved, Medina filed a complaint for illegal dismissal, actual, moral, and exemplary damages, and attorney's fees. The labor arbiter found that there was no illegal dismissal because fighting with a co-employee within work premises is considered serious misconduct and a valid ground for termination of Medina 1's employment. Issue: whether Medina was illegally dismissed. Ruling: yes. The Supreme Court held that no serious misconduct was committed by Medina. Misconduct is generally defined as a transgression of some established and definite rule of action, a forbidden act, a dereliction of duty, willful in character, and implies wrongful intent and not mere error in judgment. Under Article 297 of the Labor Code, an employer may terminate the services of an employee on the ground of serious misconduct committed in connection with or relative to the performance of his duties. To justify termination on the ground of serious misconduct, the following requisites must concur. 1. The misconduct must be serious. 2. It must relate to the performance of the employee's duties, showing that the employee has become unfit to continue working for the employer. And 3. It must have been performed with wrongful intent. Here, none of the requisites for serious misconduct is present. It was found that only a petty quarrel involving shoving or slight pushing transpired between Medina and Pogoy. It did not cause work stoppage, nor posed a threat to the safety of the other employees. G&S did not show how Medina's misconduct has adversely affected its business, or how Medina has become unfit to continue working for the company. Thus, there was no just cause for the termination of Medina's employment with G&S. The penalty must be commensurate with the act, conduct, or omission imputed to the employee and must be imposed in connection with the disciplinary authority of the employer. The Supreme Court ruled that there is no basis to award Medina moral and exemplary damages. Although Medina's dismissal is illegal, there is nothing to show that G&S was motivated by bad faith in terminating his employment. Thus, Medina was awarded full back wages, inclusive of allowances, and to other benefits, or their monetary equivalent from the time their compensation was withheld from them up to the time of their actual reinstatement pursuant to Art. 294 of the Labor Code.